Any mention? Any mention?
Please, Your Lordship. Yes, may I please, Your Lordship? I am making a mention virtually, Lordship. Lordship, in item number 2, my Lord, I am appearing for the appellant, my Lord.
You can wait for
My Lord,
a
in
minute.
fact,
You can wait for a minute, we will reach.
My Lord.
So mentioning should be
Obliged.
for listing the matter or
Lordship.
on account of
Obliged.
ill health or bereavement, etc. Otherwise, you can wait. Yes. So delay.
Lordship.
Yes.
From supplementary list, item number 1.
Oh, yes. Any objection? 560 days delay.
No, my lord, this is appeal has to be heard.
Yes. Worship, delay control. 560 days delay.
We agree to appeal. We will realize generally not the number and district.
Yes. Yes. Registry is directed to number the appeal. So on the Advocate General takes notice.
From daily list,
Court also.
This is legally better. So registry has to prepare.
It's a legal aid. So legal aid matter.
Yes, lordship.
Registry will have to make the paper book ready. 4 weeks?
Deeply obliged, lordship.
from the daily list, item number 1.
Delay of 52 days.
But we have taken steps for service of notice, my lord, and we have filed an affidavit of service, my lord, but it appears
Notice has been served.
notice has been served, my lord. We have enclosed the postal department report, my lord.
Office note indicate the service on the sole respondent is not complete. Counsel or applicant to obtain status of service and to file affidavit if necessary.
We have filed an affidavit yesterday, my lord,
Yesterday,
on 19th, my lord, day before yesterday.
you don't know. Whether it serve it on the counsel who appeared in the writ petition.
My lord, this is central excise appeal from order.
Oh,
Such
oh,
that, my lord.
yes, yes, yes. Yeah, we were under the impression it's a writ appeal. Yes. When you take another fresh notice,
My lord, it appears someone,
is anybody appearing? Item number 1. The registry is directed to print the name of the respondent in the cost list. In case no counsel has entered appearance, registry is directed to verify the proof of service and carry out the. Yes,
my lord, deeply.
after 3 weeks. Yes.
Item number 2.
May I please the lordship, I am appealing on the behalf of respondent.
You're appearing for?
My lord,
I am appealing on the behalf of respondent, the lordship. Respondent.
Yes. 187 days delay. Do you have any objection?
Yes, your lordship. I have filed a reply regarding objection on the delay aspect, your lordship. My assistant counsel handed over that reply, the short reply, and the copy of the decisions which I am relying on for the objection on the delay, your lordship. Your lordship, the delay is more than 270 days.
Not at all audible, sir.
Yes,
Mr. Sandeep.
I'm sorry, lordship. Your lordship, the delay is more than 270 days, your lordship. The delay is
More than 270 days.
Yes, the date of pronouncement of the order is, your lordship, 2/1/2023. The include order of the ITAT.
How many days for preferring an appeal?
Your Lordship, this is
My, lo-
counting from the date of pronouncement, it's more than 270 days, Your Lordship.
may I submit, Lordship?
Yes, yes, sir. My lord.
My lord, yesterday only we received a copy of the, my lord, paper book respondent has submitted, my lord. We will also like to submit our paper book. So, my lord, I am praying for adjournment today. Let it be come up
Yes.
after 2 weeks.
By the request of the petitioner, post a matter after 3 weeks for filing. Reply. Rejoinder.
Lord,
Item number 3.
Grateful, Lord.
decree of life, my lord.
Sir, ESA Act. ESA. Yes. Any mentioning? Yes.
From the daily list, item number 1.
Meet please, my lords. Your lordship will pray for some accommodation for today, my lord.
Sir?
My lord, I'm praying for some accommodation for today in the instant matter. My lord, I'm praying for some accommodation for today, my lord.
One time.
My lord.
My lord, in this matter, notice has not been served, my lord. Only respondent number 5 was a caveator, my lord, so we have served them. The
This is the
respondent,
case. You challenge a suspension order.
My lord.
we challenge them, my lord.
The challenge, my lord. I'm for the
So you
respondent.
challenge.
Madam.
Yes.
Well, the respondents are yet to be served, my lord. The district council is the respondent, my lord. 1, 2, 3, and 4.
See, they have got every right to place you on the suspension.
Well, our case, my lord, is that in terms of the act and the rules, my lord, any complaint against the chief, my lord, the CM is the traditional chief of in the Khasi system, my lord, that has to be first placed before the village council, the darbar, my lord, they call it darbar, and it has to be deliberated upon there, my lord, and thereafter, if anything on preliminary inquiry something is found, then only the matter will go.
The provision that you rely upon has already been deleted.
It has not been deleted, my lord.
Not been deleted.
My lord, in the act there has been amendment, my lord, but the identical provisions are there in the rules also, my lord.
Exactly. The provision under the Act has been deleted. When there is no provision in the Act, you cannot rely upon the rule to get the benefit.
My lord, in my humble submission, my lord, that is the whole issue to be decided by lordship in this matter, my lord. But our case is, my lord, if I may take your lordship to the act, my lord.
See, give the list of events. We'll pass orders the next hearing. See, suspension,
My lord.
they've got every right.
My lord.
You have to face the inquiry. You can't stall the suspension. How long have you been under suspension? 6 months?
It's about 6 months, my lord.
Or more than 6 months. And you'll be getting subsistence allowance.
No, there is no subsistence allowance, my lord.
How?
It's not a salaried post, my lord.
It's not a salaried post.
My lord. My lord, earlier there used to be the kings, my lord. It is virtually chief of the tribe, my lord. Tribal chief.
Ilakas, my lord.
Oh, that's what it is. When do you want?
The 2 weeks, my lord.
First week?
2 weeks.
2 weeks?
My lord, before independence, the entire Khasils were divided into 25 kingdoms, my lord. So there was a king of each 25 of those kingdoms. So he is one of them, my lord.
Yesterday I read the entire paper, but I have to read the Act and the provisions. Then I'll come prepared.
But, my lord, in the meantime, we may serve notice to respond number 6 also, my lord.
Yes. The appellant is permitted to serve notice on the unserved respondents,
My lord.
returnable after 3 weeks.
My lord.
Yes.
Much obliged.
Deeply.
Item number 2.
May it please, Lordship. Lordship, state is in appeal against the order of learned single judge.
My lord, before learned HC proceeds, may I just pointed out the requirement of filing the writ appeal under the High Court rules. A writ petition filed by the appeal as in now, it is not maintainable. When we look at chapter 3 of the High Court rules, it is very clear that when a party prepares memo of appeal would be along with the copy of the authenticated copy of the writ petition, counter affidavits, rejoinders, relevant annexures, and all the exchange of pleadings. Now, in this writ appeal I've gone through, my lord, the writ petition is not there. Counter affidavit filed by the party is not there. Rejoinder is not there. Paper book prepared before the writ court, it is not there, my lord. So it is difficult to proceed, my lord, in this form.
The matter came earlier, my lord. So this court observed to prepare compilation of the documents. We have prepared compilation.
Compilation,
And where we have got placed everything, and it's very short question of law, my lord, very short question of law.
It is not.
He's giving all the papers.
Yeah, I have already given the papers, and I will give the entire sheet also, my lord. If your lordship will see the last order of your
So
lordship.
it is only a procedure, sir. See, we can look into the writ petition papers, we can forward the records.
My lordship may go for records. I have no problem.
Okay?
But the problem is, my lord, as of now today, the copies are not there.
You don't have a copy.
I have the spare copy. I will argue the matter.
If you don't have a copy, take it from him.
Yes,
I,
copies are there.
See, it's only procedure, not substantial one.
It is
You must
procedure.
understand that.
It is procedure, no doubt. It is procedure. No doubt.
For the convenience sake, procedure has been adopted. Which is followed. If they don't file it, then we are entitled to say call for the records.
Lordship can do that, but I just pointed out before
Take the
proceeding.
papers. If you are ready, we'll hear the matter
I'm ready, ma'am.
some other day.
I'm ready, ma'am.
Ready.
I'm ready. The lordship process.
Your compilation is there, which contains every records, my lord, and judgment, relevant judgment, case laws also, my lord.
My lord, with your permission, my lord. Writ is not there. Readings is not there. What the very senior is.
Please read also.
We'll call it after 2 weeks. You go through it.
It is not there. It is not there.
This read is there.
Writ petition is my lord, early writ petition. Different writ petition here next.
I have
Different affidavit filed in different writ petition here next.
place like this, my lord. If document is missing, I will supply it. But according to me, I have placed all the documents. Whatever is issue, you will feel that some document is required, we place
It
it.
is not there. It is my duty to point out.
Let me place.
You tell him what are the documents that are missing. We'll ask him to file it.
I'll file it. I'll file it. That's not any problem. my
We'll
lord.
call it tomorrow. It's not a problem. Tomorrow.
Tomorrow.
My lord.
Go through the papers. We'll hear the matter. That's all.
Because there is some urgency, my lord, because check gates have been set up by customary heads all across the state, saying that they have the right to collect the tolls from mineral laden vehicles, my lord, and that is creating a lot of problems.
Continue. We'll see. We'll
place one-
verify. If what are the documents available, you inform him so that it will give it to
I'll
you.
inform the landed AG, the missing papers.
I'll place it also.
Item number 3.
Request of the parties post the matter on tomorrow.
Grateful.
Correct.
Circulation. You send it to circulation. I'll read it. Yes.
Mr. Lordship,
Yes.
Lordship, we have a final application for condemnation of a delay of 94 days, Your Honor. For this,
Condemnation of delay.
yes, Your Honor.
How many days is it? 94 days delay.
94 days delay, Lordship.
Notice allowed to go.
Notice we have served to the counsel of the petitioner, but he refused to accept the.
Where is the endorsement saying that he has refused?
No, we have to serve notice, Lordship,
If it is refused, then it deemed to have an acceptance.
because they are the private counsel. Private respondents. So
You are appealing for the ESC corporation.
yes, Lordship.
Which provision supports your case?
According to Meghalaya rule, chapter 3, rule 4,
What Meghalaya rule?
No,
No, not on delay, not on the delay, on the merits.
on the merits.
Which provision supports your case?
Lordship, actually, there's a,
ESI Act.
yes, Lordship.
You don't have a copy, ESI Act, 1948.
Lordship, in this matter, the single learned bench have passed and judgment and order. Actually, in this matter, Lordship, this section 75 of the ESI Act clearly says that no civil matter can be decided. I may just go through, Your Lordship. 75, clause 3 or subsection 3. No civil matter have the jurisdiction to decide or deal with any question or dispute as aforesaid, to adjudicate on any liabilities which by or under this Act is to be decided by a medical board.
Civil court has no jurisdiction.
Yes, Your Honor.
Right.
And actually over here, Your Honor,
But which provision supports your case? You said civil court owns jurisdiction. Which other provision support your case? You read 75G.
yes. Yes, Your Honor. Any other matter which is dispute between a principal employer and a corporation, or between a principal employer and an immediate employer, or between a person and the corporation, or between an employee and a principal or immediate employer, in respect of any contribution or benefit or other dues payable, recoverable under this Act, or any other matter required to be or which may be decided by the Employees Insurance Code under this Act.
So any other matter which is in dispute will have to be decided only by the ESA court.
Yes, Your Lordship.
Order. That's the only point.
Yes, Lordship.
There are a number of judgments in your favor.
Yes, Your
Do you
Lordship.
have a copy of any one judgment?
But today I did not bring Lordship because I thought just condone the delay.
ESA, is there any ESA court here, or the labor
Yes,
court
yes,
is constituted as an ESA court?
There is ESI court.
There is an ESA court. Which court is functioning as an ESA court?
Now there's at
In Tamil
present.
Nadu, there is no court as ESA court. The labor courts are designated as ESA court. Here,
Yes, we have Lordship, but this time.
separate ESA court is there.
Yes, Lordship. Yes.
You have not brought to the attention of this court to the 11th single judge about 75G. And there are a number of judgments.
Actually,
There are a number of judgments in your favor, saying that ESA court alone is competent to decide the matter. So get the judgment.
Lordship, actually,
Don't make us search.
this matter was handled by the other colleague.
That cannot be a ground. That surgeon is not there. Now you are the surgeon. So you have to do the surgery properly.
Yes, Lordship.
Yes. Your friend is not, who appeared before the 11th single judge for them?
Before Mr. Depp, S. Depp, Your Lordship.
You served a copy on him.
Yes.
Where is the proof?
Last time we have already served, he said that we cannot accept since it is a private case, so let the notice go to
That is
the.
right. Probably you would have said that, like you are entering appearance for for the first time, they may engage different counsel. But there is no less chance, because you have succeeded before a single judge, they may engage the very same counsel.
Yes.
You take private notice
Yes, Your.
on the respondent.
Yes, Lordship.
Private notice returnable by we are on 21st, 4th or 5th, Tuesday or Wednesday, sir. 4th is Monday, 5th or 6th. We are Thursday, we are Wednesday. Wednesday. Post on 7th April. Not 7th. 7th we are going. On 6th April. 7th we will be traveling. 7th of March. Sorry, 7th of March. To take out judgments, there are a number of cases under 75G.
Yes, Lordship.
One other point is also in your favor. After section 45A, there is an order passed under 45A. Against that, there is an appeal under 45AA,
Yes, Lordship.
amended act. Of course, the period of limitation is 60 days and 25% of the amount will have to be deposited. So in 75, in the 77, you can file a petition for waiver.
Yes, Lordship.
It's for the ESA court to decide. Yes.
Lordship.